In a landmark ruling against Eskom and load shedding, the Gauteng High Court in Pretoria unanimously ruled that load shedding violated multiple constitutional rights. The court ordered the Minister of Electricity to ensure that all public health institutions, including hospitals, public schools and police stations, are exempt from load shedding by the end of January. We take a look at this with legal analyst Advocate Romeo Nthambeleni. Thank you very much, sir, for your time this afternoon. Perhaps let's take a look at page 4 of that judgment under summary. I do wonder if we can bring that graphic up for our viewers so they can read together with us. It reads, and I quote, "If courts could end load shedding, they would, but they cannot, and it is not their function." The relief sought in 3 consolidated applications center around this conundrum. There are 2 themes. The first is the relief to be granted pursuant to the failure by organs of state to provide consistent provision of electricity. While the Constitution does not expressly provide for a right to electricity, it guarantees the right to other aspects of life which cannot be provided or function properly without electricity, such as the right to proper health care, the right to education, the right to water and sanitation, and the right to be protected by the South African Police Services. What to understand about this more so, while the Constitution does not expressly provide for a right to electricity, it does guarantee certain rights.
Good morning to you and the viewers. Thanks for reading that part of the judgment. It confirms the position of our Constitution that is aligned to socio-economic rights. So the court was indicating that even though there's no guarantee of the right to electricity on the Constitution and our socio-economic rights is actually linked to the right to electricity. That is why at the end the court found that they have to declare that the load shedding is actually unconstitutional, and it offends against the rights that you have rights such as the right to human dignity, right to to health, and rights to safety and security, which those rights are definitely covered by the Bill of Rights in the Constitution of the Republic of South Africa.
It further reads that the second theme centers around a review application launched in order to determine whether the tariffs whereby Eskom recovers revenue sufficient to cover its cost of electricity generation and distribution were correctly determined by NERSA. The court notes that the reviews against the NERSA tariff determination were refused. Do we know why?
Yeah, because the matter became mute, and when it became mute, it's many organizations that were bringing that argument withdraw from the application, and we were left with only Action SA, who were actually arguing that the load shedding actually offends the Constitution and the constitutional rights of the majority of the South Africans, and the court actually looked at that. And I think what is important also to reflect upon is that the court again confirmed that at the time of Part A, when the Part A was being dealt with, there was an appeal that was lodged by Minister Gauteng, and one of the grounds that he raised was the issue of separation of powers, because he didn't have the capacity or the authority to actually deal with the issue. But now, there's a Minister of Electricity that has been appointed that is tasked with the responsibility to deal with the issues that were raised by the court. Hence, the court issued the order and gave him the opportunity to redress these issues in relating to public schools, police, and hospitals by at least the end of January next year, the 31st.
Right, and that's part of the order. I do wonder if we can bring that up too so our viewers can read with us, because firstly it notes that it is declared that the non-realization of the government's intention in the late 1990s to open the energy sector to competition with private actors and to timelessly implement the independent power producer procurement program, the delays in the decisions and implementation to build Mudupi and Kusile power stations, the decisions to run power stations beyond their capabilities without proper maintenance, the failure to ensure or approve sufficient revenue for its services, and the failure to take adequate steps to protect Eskom from criminal activity, corruption and state capture individually and collectively, and the resultant energy crisis manifested by load shedding and the continued failure to remedy the crisis constituted and still constitute breaches by the respondent organs of state to protect and promote the rights contained in the Bill of Rights. Ultimately, that the court court would come to this judgment, which is something that we have been hearing, to be fair, from many sectors of the society, should tell us what, though, more so when it comes from the courts, about the state we are in?
Absolutely. It's an important point to note that the court indicated that there was failure on Eskom to actually deal with the capacity issues, and you've given the examples of buildings of power stations, so that we don't find ourselves in a critical state that we are in. And that failure was put at the doorstep of Eskom and government, that they were supposed to generate enough capacity so that this doesn't have an adverse impact on the economy and the society, and also the employment, because you should know that that also affects employment in relation to power being off and small businesses being affected, being the ones that are at the brunt of being affected adversely. And the rates in relation to unemployment in the country. So it worsens the situation, and the court were putting it back in the doorstep of government and Eskom, and they linked it also to the state capture that has actually happened, and that affected Eskom as well.
Should there be concern, Mr. Nthambeleni, more so when the court speaks of it is declared that the non-realization of government's intention in the late 1990s to open the energy sector to competition with private actors and to timelessly implement the independent power producer procurement program, should there be, maybe not concern, but consideration, because this is now said that we need to do this timelessly, but when you take a look at the words state capture, are we not concerned that history may repeat itself so soon, because there might be processes that are sidestepped as a result of wanting to solve this crisis so quickly? Should we be paying more attention to this aspect in particular?
Yeah, you're quite correct. Look, the ship has sailed, and we are finding ourselves in this situation because of those failures that the court has actually reflected upon. But on a positive side, we look at this appointment of the Minister of Electricity, who is tasked with the responsibility of redressing the very same issues that we are actually talking about. So I think now, as this order has been given by the court, that the government will take it and reflect very seriously on it to actually resolve it speedily, so that all these challenges that are being addressed by the court in this issue are being addressed swiftly, in order to try and deal with this problem that is adversely impacting the right to education, the right to health, and the right to human dignity of the majority of South Africans. So it's quite important that there must be a serious reflection on the side of government as to how they are going to actually tackle this and reverse it as an injustice of that is being suffered on a daily basis by the South Africans, and majority that are poor, and that are adversely impacted by this load shedding.
The court has also ordered that each party pays its own costs. Why?
Yeah, you see, in terms of the cost, the court is the one that makes an ultimate determination as to why each and every party must pay their own costs, depending on how the matter was opposed and the matter, how the matter was argued before the courts. The courts. And as I've indicated, that the court actually respect the separation of powers, and when they feel that there's no need for costs to be paid by the state, they then order that each and every party must carry their own costs. I believe that is the reason why.
A consignment has arrived in South Africa in the form of generators from China, and that is said to be that is said to plug the gap in spaces that have been identified by the courts, for instance, schools, hospitals, some police stations, we understand. So I guess it's -1 on the part of government?
Yeah, you're quite correct. But let's see as to what is going to happen, because what is good is that the court has given the time frame. It says by the 31st of January, all these issues must be resolved. There must be no government, no police station, no school that does not have capacity. When you are load shedding, you must not load shed all the institutions that we have made, we have mentioned. So those generators that you are actually referring to, if they are there, to be able to assist. Let's see if ever they'll be able to have enough capacity to carry the state through this order, so that at least this order is complied with. If at least the order is complied with, to at least we have ticked one box in relation to what the court has actually directed that it should happen from the side of the state.
Advocate Romeo Nthambeleni is a legal analyst. Thank you very much, sir, for your time this morning.